Lawyers of Reddit, what was your hold it moment where you knew you would win? Story 1. I had a client charged with battery. The alleged victim didn't really support the prosecution's case and, in any event, was reluctant to testify. They still had another witness, though, and she said that my client was hitting the alleged victim, so it wasn't looking great. The prosecutor and I were talking before court started, hanging out by the courtroom doors when the witness walked in. She looked right at my client, who was sitting not 5 feet from me, then scanned the room and said, "Where is client name?" The prosecutor and I looked at each other for a minute, and then he said he needed to check on something. When I saw him a few minutes later, he told me he was dismissing the case. Story 2. I was testifying for the defense. A young man had been arrested for assaulting a police officer, allegedly throwing bottles during some unrest in Oakland following the verdict in the trial for the cop who shot Oscar Grant in the back on the BART platform. I'd been there filming stuff, caught his arrest on video, and his brother found my footage on YouTube and asked me to testify. I had only seen bottles being thrown from this one corner of a parking lot, from behind me, with the bottles flying over my shoulder. The defendant was in a group in front of me. On the stand, the prosecutor seemed to think I knew the defendant and was there basically committing perjury on his behalf. I explained why I had been there that night, that I had never seen this guy before, hadn't been coached by the defense, and hadn't been paid other than a small amount for my travel and time. Finally, exasperated after much back and forth, the prosecutor says, "Well, if you don't know the defendant, then why are you here testifying for him?" I thought for a moment and said, "I guess I just wouldn't want an innocent man to get convicted for a crime he didn't commit." He got visibly flustered and quickly moved on, trying to insinuate that if I didn't know him, how would I have known to be looking in his direction to see whether he was throwing things? And I tried explaining that if you're looking at a group of random people and one of them throws something, you will naturally fixate your attention on that person. But because nobody in that group threw anything, there was nothing to notice in the first place. It looked like the police just grabbed him at random. They rested. The defense attorney bought me lunch down the street, and then he got a call from his colleague that the jury took all of 10 minutes to return a not guilty verdict on the assault charge. They said my response was legendary, though, and that no attorney should ever ask a question they don't already know the answer to. This guy just seemed to have a narrative about a prior relationship to the defendant that he assumed was accurate, and was trying to call my credibility into question. Story 3. When the petitioner's attorney called me my brother's name when I was on the stand. My brother is a bag, and I don't associate with him anymore. But dude has a lengthy criminal history, and it pops up on traffic stops occasionally. So I was in court over custody of my oldest, and her mom's attorney was trying to paint me as a hypocrite for being an addict. I denied it all on the stand, and he said, "Now, James, I must remind you that you are under oath, and by denying this you are committing perjury." I stared him dead in the face and said, "My name is Bill. James is my brother." Even the judge laughed at him, and the only reason we didn't bring it up sooner, we knew he submitted it as evidence but had no idea why, was because I really wanted to know what he was up to with it all. Story 4. We had some huge issues with a landlord, trying to enter without letting us know beforehand, not answering to fix issues, very aggressive when talking with us. When he decided to sell the place, he didn't check with us about the visits and just showed up randomly with potential buyers. We told him to get lost. He eventually left but called us the same evening to threaten us. We sent emails to remind him of our rights as tenants, and he answered by threatening us some more, in an email. We eventually end up in small issues court, not from the U.S., don't know the name, and he fabricates a story about how we are terrible tenants and we try to discourage buyers. We just showed the judge the emails as well as the open complaint to the police we filled a few days earlier. The judge couldn't believe it and gave him a formal warning, gave us 3 free months of rent. In the end, the guy just used a real estate company to sell the place. All went smoothly, and we still live there with lovely landlords that aren't completely bonkers. Story 5. My client was riding his motorcycle on a relatively calm street when this guy exited his garage without looking and run over him. In deposition, the guy brought a witness that was with him on the passenger seat. The whole time, the witness maintained that my client was driving too fast and that there was no time to brake the car. I asked him the same question a few times in different ways, making him tell the story again. In the fourth telling, he, already a bit frustrated, let it slip. "Look, I've already told you. We were exiting the garage, and as soon as I lifted up from getting my cell phone on the car's carpet..." "Wait, so you didn't even see the crash?" "There was no coming back from that." Story 6. It was my 3rd month of practice. I was in family law at the time, representing Mom in a petition for a restraining order against boyfriend Dad. At issue in the broader case was child visitation, custody, support, etc. But today's hearing was just on the RO. We had pretty good facts, but it was mostly asterisk, based on testimony of the parties. My client was way more reputable as a witness, so I was feeling confident. 10 minutes before the hearing, my client shows up. I give her a last-minute prep on what to expect, and then she says, "I'm glad I'm going through with this. I can't deal with it anymore, and he's just getting worse." To top it off, he left me a drunken, ranting voicemail on Saturday. "You have your phone with you?" "Yes." We play the voicemail, and it's a full 2 minutes of ex-boyfriend screaming cow like, "I should have flipping terminated you when we were together. You were always such a bad person. I hope you burn to death in a fire." I didn't have time to ask her why the fudge she hadn't said anything to me about the voicemail before the bailiff called our case. We sit. The judge asks if either side has additional evidence, and I ask for permission to play the voicemail. Ex-boyfriend, who didn't have an attorney, didn't object, so I played the whole nasty 2-minute rant in open court. Judge goes, "We're going to take a brief recess before I issue my ruling. If the parties want to meet and confer in the hall, they are welcome to." Boyfriend knew he was messed up. We settled the whole oh-no case then and there. My client got her wish list in terms of custody, supervised visitation, child support, plus the restraining order to boot. Story 7. When I practiced insurance defense. Was handed a file to take over of a slip and fall. Guy tripped on a hose, tore his ACL. The partner had taken the guy's depot already, so I read the transcript. I'm a Michigan football fan. Watched every game for 20 years. This guy testified he was the starting safety for a certain rival for certain years. Also that he graduated with a double major that doesn't exist at that school. I immediately knew this was false. Partner didn't understand. Dug deeper, lied about so much stuff unrelated to the fall for no reason. Eventually found high school records from football injuries of head trauma, knee injuries, and a slip and fall injury a few months after ours. He also testified he rehabbed an ACL surgery after 1 month. Motion for fraud on the court filed, immediately settled. Story 8. Very abbreviated. I was prosecuting a convenience store owner for luring a young girl, who regularly came into the store, back to a part of the store to grope, fondle, and kiss her. Child enticement. It was the only section of the store without surveillance camera coverage. They were in the back room for about 2 minutes and 17 seconds, per the time stamp on the videos. Of the many arguments the defense put on, one was there was no way there was enough time for anything to happen. In my rebuttal on closing, I asked the jury to imagine what could happen in the room in that amount of time, and I asked them to all close their eyes while I timed out 2 minutes and 17 seconds on my watch, in silence. After about 60 seconds, 2 of the jurors started crying. Knew it was going to be guilty right then. Story 9. I represented an elderly Indian couple who didn't speak English very well and owned a rental property. They had a tenant at the time who had not paid rent in over 6 months. They had tried to evict her on their own, but when they got to court, the tenant produced some handwritten notes which they had given her the year prior, thanking her for payment. But they failed to date the notes. Of course, the tenant added recent dates herself. The tenant also produced a partial certified check receipt, but most of it was illegible. Anyway, because of their poor English, they had difficulty understand the questions and giving intelligent answers, so they lost the initial case. They hired me to help address all of the various lies that the tenant was putting forth. Anyway, we refiled. I had my clients pull the banking records, so we could show the date that the certified check was actually deposited into their account. The plan was simple. Let the tenant make the same arguments and then present the banking statements showing the deposit date. My clients also found a photocopy of one of their notes, but it was undated, unlike the copy the tenant presented the last time. Well, when the judge finally understood that the things the tenant had presented occurred the year before, his cheeks turned bright red, and he asked the tenant, "What year did you make this payment?" The tenant started saying something like she couldn't be exactly sure when, and the judge cut her off again in a very loud voice, "What year?" Needless to say, the clients got their eviction granted. Bonus content. When the tenant arrived at court, I watched as she got out of her car, walked to the back and pulled out a wheelchair and proceeded to stay in that wheelchair until the case was over. Once the judge left the courtroom, she folded up the wheelchair and carried it to her car, mumbling that she hates hashing lawyers. Anyway, that was a very satisfying day. Story 10. My client was accused of brutally murdering a dog. Cop testified that there was no testing of the blood, no body ever found, and admitted it could have, in fact, run away. The eyewitness said she could see the terminating down the hallway from the dining room. Cop testified there was no hallway, and the dining room was on a different level of the house than the terminating supposedly took place. Then the person who was leading the lynch mob against my client around town for the last year testified that she had been in the apartment between the two visits by the cop to evaluate the scene. No body, a compromised crime scene, witness who couldn't see anything, and admission that there was no proof the dog was dead. Closing argument lasted 3 seconds. Your Honor, I'm asking for an acquittal. Edit. My first award, thanks. For those who asked, this was in Canada and received a fair bit of media attention prior to trial. Story 11. Not a lawyer, but we had no evidence that the woman who slammed into my stopped car going 85 miles per hour was drunk, until she indignantly admitted it on tape in her deposition. She busted into my deposition and demanded she go first because I was a lying bad person. She excitedly told my lawyer that the police report was wrong because it said she was coming from the movie theater when she was actually coming from her friend's bar. Did you have anything to drink at your friend's bar? Of course. How many drinks? I don't know. They just keep my glass full. Did you take any medicine that day? Methadone and low blood pressure medicine. I see. The cops had refused to breathalyzer her at the scene because her husband was a firefighter that they knew personally. They told her to go home, sober up, and go to the hospital later. I heard the whole thing but had no proof until she handed it to me. They settled same day. Story 12. Not a lawyer. Years ago, I had to do something at a strip mall in a bad part of town. Took me about 20 minutes, and then I found that my car had been towed. Ubered to the tow yard. Giant sign says cash only. Had to call another Uber, drive to the ATM and back, and pay them $300 some bucks. Got a poor handwritten receipt that, believe it or not, was itemized. Went home, Googled, found that they violated the law in 3 separate ways. Towed illegally, illegally refused to accept credit cards, and had multiple charges that the law called unreasonable, like dolly fees, and load, unload fees. Took them to small claims court. The judge began by asking the tow yard owner about his relationship with the property owner and how the decision was made to tow my car. Oh, the slimy tow truck dude answered, my cousin works there. If he says to, I tow. It's 100% legal. The judge's eyebrows began to rise. But, the dude continued, but what I detest the most, Your Honor, is this unpleasant person claiming I don't take credit cards. I'm a businessman. I take credit cards all the time. He's a lowlife that does not have any credit cards. That's why he wanted to pay cash. I was having a hold-it overload, and the judge saw me smiling and hopping in my seat and patting my manila folder of receipts. Do you actually not have any credit or debit cards? The judge asked me. I pulled out my wallet and showed him, and then I pulled out a time-stamped photo of the cash-only sign I took the day of, and another one I took the morning of the hearing. The guy mumbled something like, okay, you got me there, and then had nothing but, huh. I didn't know that. When the judge asked him about the legality of each unreasonable itemized charge. Anyway, each violation pays double the total tow charge, and since there were 3, that's how I made $1,800 on a $300 investment. Story 13. I can't believe I'm about to use the not a lawyer but loan, but here goes. LOL tried to sell my home myself, and the buyers wanted a term period for land contract before getting their own mortgage. I agreed to 1 year, had a simple contract drawn up, and after we both signed it, everything seemed fine. Within 30 days, the present me with their own legally drawn-up land contract that was pages long to protect their investment. About page 3, it very clearly stated that if for any reason the home burns down, purchaser will receive all insurance proceeds. First, I still had a mortgage, and the proceeds would legally go to pay that off. Second, that's a pretty targeted thing to say. Not lawyers' terms of the house being destroyed, and it's surrounded by woods and waterways just if it burnt down. Page 4 stated that this would remain a land contract until my mortgage was paid in full, so they'd never buy outright. I returned it to them with a letter stating those 2 things were never happening, and I wasn't signing. They stopped paying, so I began eviction. 6 months later, the lawyer I hired was an idiot, and I'm sitting down with their lawyer myself. He brings out the contract they'd tried giving me, and began talking about their ironclad case due to the agreement. I asked him to show me my signature. The look on his face when he realized it wasn't there. After we talked, it turned out he knew them and wrote the contract without the burn the house down stipulation, seems they added it, and under the belief it was a long-term land contract. Not only did I win, I'm pretty sure they lost a lawyer friend. Story 14. Bought a hurricane door from a contractor that was found through our state's hurricane readiness website. He took $5K and after about 3 weeks of car or scheduling issues, finally just ghosted us. Took him and his company to court. The him and his company part is important. Finally, court day shows up, and I'm fairly young and an optimistic, so I figure I don't need a lawyer. Plus, the local news station took my story and came out to interview me to do a bit on it. I figure it is a fairly obvious case. Easy win. I put on my best only $99 suit and head downtown. Dude doesn't show, but instead sent his company's office manager. We get settled in with the arbiter. First thing I was wrong about, oh, cow, not court with a judge and cow. And the office manager starts in that they deny my claims and, in fact, are countersuing me for canceling the contract. I start to sweat, like, oh, cow, they're going after me? What happens if they believe them? I'm going to be out $5K and have to pay them more? FML. The arbiter listens to her and then asks me to tell my side. I told him, plus showed documentation of what I had did and when. Arbiter dude looks at her and says, he has enough to prove you wrong by, even if he didn't, because your boss, Michael blah blah, couldn't even be bothered to show up when he himself was specifically named in the suit. I'm ruling in the plaintiff's favor. Cue me trying not to happy dance or look too smug before I got out of that room. Side note, just because you win a judgment against someone, that doesn't mean you will get paid. You still owe me $5K, Michael. Story 15. Not exactly a knew you would win moment, but I got a hidden shout-out from a federal judge in a ruling that I consider to be one of the high points of my career. Here's what happened. Before a hearing for an emergency injunction against USDA, I was watching the hearing before mine, a trademark infringement case. At the end of that hearing, the judge accidentally used a pun and could not stop laughing. She was literally crying. I decided at that moment I was going to intentionally use a pun in my hearing. I did. I accused USDA of engaging in a shell game by illegally diverting some federal funds to an egg industry trade group. The judge called me on it but laughed heartily. My client won. The judge threatened to put the Secretary of Agriculture in jail. A major newspaper reporting on the case said the judge winced at my puns but agreed with my arguments. False. When the written ruling was issued, the last sentence said that an injunction was issued against USDA's use of the funds for any plans they may be hatching. Undeniable shout-out. Story 16. Not a lawyer, but was working as a paralegal for a law firm. We were defending a claim which had run into tens of thousands of pounds against our client, a holiday home, by a woman who had tripped over a speed bump while walking back to her caravan and damaged her knee. The fall was genuine. The question was whose fault this was. She claimed it was the holiday home's fault because she hadn't seen the speed bump due to low lighting, poor marking, etc. The claim had outrageously gone to months and made it to court. Going through the various questions to her, when our barrister asked how she knew the speed bump was poorly marked, or something similar. Her response, well, I remember thinking how it wasn't well marked when I was walking up to it. Needless to say, it was a short day in court after that point. Story 17. Not a lawyer, but I played one in small claims court. My lease had an exit clause that said if I fronted 2 months' rent, they would work to lease my place and return anything unused. I checked with the office ahead of time. They ensured me there was a waiting list, so I gave them the 2 months and moved. They never returned a dime. I talked to the new tenant and confirmed they moved in a week later. In court, the judge was commenting on how he didn't see anything explicitly saying they would return any unused rent, even though that intent was stated to me a few times. Dumbo from the leasing office piped in with, Your Honor, in almost every case we can return some money, but in this case we didn't have a tenant in the 2 months after he left, so she gave the case back to me, and I presented the affidavit from the new tenant confirming the move-in date. Judge awarded me double what they owed. Turns out leasing office Dumbos 1 and 2 thought they could lie to me and return my excess rent money to themselves. Story 18. Not a layer, but my girlfriend had a very minor nose to tail, and a rookie cop who happened to drive by booked her on some massive charges and fines. She went to trial, and her lawyer tore apart the cop. In the report he filed, the officer ticked her ethnicity as African, she's white, European, put the wrong date, the wrong street name, and didn't get the other witnesses' details. The prosecution officer argued that she had signed the witness statement, so while a few things were accidentally filled out wrong, it reflected what happened. Her lawyer asked the officer show the court her signature on the statement. He looked at it and said, Oh, I must have forgot it. The prosecutor and a few police that went to the trial for some reason all let out audible groans. The judge adjourned for 10 minutes. The police still wanted to press on, but the judge threw it out immediately after recess and gave the prosecutor an earful for taking such a ridiculous case to trial. Story 19. Not a lawyer. I was a volunteer family advocate. I worked with families who were falsely accused of child abuse. Part of that was going to court with them. I was contacted by a family whose children were in foster care because of parental candy use. The family claimed that they didn't do sweets and that no one would believe them. They had a court-appointed attorney who did nothing but tell them to stop using sweets. I honestly didn't believe them. I was pretty jaded. I told them to request their case file for me to review. I was surprised when they called me back and had the case file. I met with them and went through everything. I noticed claims of candy use, court findings of candy use, but no test results in their paperwork. I told them to ask for the results. Long story short, the caseworker wouldn't give them the actual results, and the lab wouldn't either. So I candy tested them myself at a different lab. They tested clean, color me shocked. There were 4 months to go until the next court date. Every time CPS Candy tested them, they went right after to the other lab and did a second test. All clean. I told them to tell the lawyer beforehand that if CPS claimed any dirty candy tests, to ask in court for the test results. He didn't want to. I was starting to get mad. So, the day of court, I had a stack of clean candy test results in my bag. The lawyer wouldn't even look at them, and he was openly hostile to my presence and involvement. Court starts. I had been in this judge's courtroom before with other families. The CPS supervisor stands up and says that the parents have had 12 dirty candy screens in the past 6 months. The lawyer actually did ask her for the results. She said she didn't have them with her. I got the results out of my bag and handed them to the mom who was next to the lawyer. She tried to get him to take them, but he ignored her. I got so agitated that the judge said, "Mrs. Baez looks like she's about to have a stroke. What's going on?" I stood up and explained that we had clean candy tests taken immediately after the mandated ones that CPS claimed were dirty. I briefly explained that the parents had tried getting copies of their results and had been refused. I said that the parents had consistently denied ever using sweets and had clean tests to prove it. The judge ordered CPS to provide copies of all the candy test results at a hearing in a week. At that hearing, the case was closed and the children were released from foster care. The family never got an apology from anyone, but they were too traumatized to pursue it. They packed up and moved away within a month. Story 20. Not a lawyer, but just a very observant girlfriend. My BF's car was involved in an accident. He was parked in an area where during certain hours, you were not permitted to park as it would block semis from being able to maneuver to deliver goods. It was a steel plant. A girl backed her vehicle in his driver's side door of his Ford Fusion. Cops were called for insurance purposes, and my BF states that it appeared the cop and the girl knew each other. They were on a first-name basis. He received a parking ticket. It took forever for the insurance companies to sort it out because she didn't think she was at fault because he was parked illegally. That doesn't matter or make legal for you to hit someone's car and get off scot-free. She ended up having to pay for his deductible. And this is where the harassment from the local PD began. He received a piece of mail from our magistrate stating he failed to pay a parking ticket, and a bench warrant would be issued if he didn't pay it, or he could request a hearing regarding the ticket. He was just going to pay it. I looked over the paperwork and found that the vehicle they said he parked illegally was traded in before the ticket was issued. The ticket indicted a white Toyota Tundra, but the license plate block was not filed out. It was signed, but you could not make out the badge number. We had traded his Toyota Tundra on a Ford Fusion in December. The ticket was written in Feb of the following year. I was pretty pissed. I gather all the evidence for him, trade and paperwork, and he went before the magistrate. Cop testified that he saw a white Toyota Tundra illegally parked at a certain location that had a parking time restriction, and it was owned by my BF when he ran the tags. I should note that my BF had had several parking tickets while he owned the Toyota Tundra. That's our guess on how he got just enough info to write the ticket. My BF presented his evidence and the judge dismissed the case. The judge was heard to say to the cop that he would like to speak to him afterward and chastised him for wasting the court's time. The cop later told me BF that had he contacted him, they could have taken care of it outside of getting the magistrate involved. Needless to say, we haven't had an issue since. Story 21. Ional. But a friend of mine was a DWI attorney in New York for a while. He was defending a guy who was asleep in the backseat of his car while intoxicated, and an NYS trooper arrested him. On the stand, the trooper testified that he visually saw the key in the ignition. My friend gave him like 3 chances to walk it back. Are you sure, trooper, that you actually saw the key in the ignition? Yes, counselor. When a cop calls a lawyer counselor, he really means unpleasant person. And then my buddy dropped the hammer. You are aware that my client drives a Toyota Prius? Bam. Edit. 13 hours later. For all the people pointing out that there's a spot for the fob in the dashboard of some Prius models, etc., you have to understand that in a court of law, words have meanings. Ignition is most certainly specifically defined in NYS law as being what we all commonly understand as the ignition. The point is that the trooper, since their main duty is traffic enforcement on the roads, are expected to be experts on the cars. Also, he lied on the stand. He wasn't mistaken, he made it up and got caught. Yes, in NY, having the keys on your person while in the car is being under control of the vehicle and thus can be arrested for DUI, DWI. But you can't sever the perjured testimony from the rest of the case. He lied, he got caught. My buddy moved for immediate dismissal and the DA didn't argue. Case dismissed. Nothing happened to the trooper. As to why the trooper did this, promotions over time? Imagine you're running the entire New York State Police. You have about 5,000 troopers. What metric do you use to gauge how effectively they're performing their tasks? For the most part, troopers ride alone. So Trooper Hash, one drives around all day on his shift and issues 0 tickets and makes 0 arrests. Trooper Hash 2 manages to issue, say, 5 tickets a day and makes a DWI arrest 4 times a month. You're going to assume that Trooper Hash 2 is doing his job. An aggressive officer is one that has a lot of tickets and a lot of arrests. Also, court appearances are almost always on overtime. Police unions are very specific about overtime pay rates and when they apply. If you're an effective trooper and you write lots of tickets, you're going to be in court a lot at 1.5 your hourly rate, sometimes 2.0 your hourly rate, depending. Also, no. ENL has long been internet speak for I am not a lawyer. Story 22. Not during trial. Happened to me personally. I got into a car accident. Another driver crashed into my car. The driver was such an unpleasant person, talking tough, blaming me, saying that he knew a bunch of lawyers. And here's the kicker. He threatened that he was going to take me to court. I'm a laid-back dude in contrast, and I was cordial to him. We went to the police station and made our statements to the traffic investigator. I didn't have a dash cam at the time, but a day later I got a copy of the CCTV footage that was looking directly at the scene of the accident. I showed the investigator the video, and he was absolutely stunned how wrong the other guy was. At that point, I told the investigator that I was an attorney and that I'd decide if I wanted to take the matter to court. Following day, I got a call from the guy who hit me. Apparently, he said he also saw the CCTV footage and he had called to settle things. I was just shocked because this dude who was previously Mr. Alpha Male did a total 180 and was suddenly polite and respectful. Amazing what an impact video has. Story 23. Watched my lawyer have this moment last time we were in court. Short version. My ex abused my kid. I withheld visitation and hired a lawyer. I offered supervised visitation with a plan to integrate regular visitation once he completed anger management and parenting classes, as well as had 6 months clean of all substances. When he was on the stand, he mentioned that he had been taking prescription meds for 10 years. To illustrate that he's been on meds for a decade and never had a problem being a good dad, lawyer asked what meds, and he listed off a bunch. Meds like methadone, Klonopin, Vicodin, OxyContin, etc. She asked why he began taking those particular medications. He replied, "Well, I messed up my back last year riding my quad." She asked him to repeat himself. He said it again. The look on her face was amazing. She said, "So you've been taking large amounts of meds for 10 years?" He said yes. She said 10 years of major medications due to an injury that happened 2 years ago? Story 24. Not a lawyer. Was contesting a speeding ticket. In front of the judge, it went like this. Judge, Mr. Crookie, you were given a ticket for doing 40 in a 30 area that's also a school zone on Turnpike Road. How do you plead? Me. Your Honor, there is no school zone on Turnpike Road. The judge looks at the paper again, then looks at the bailiff. There isn't a school zone there, is there? Bailiff. No, Judge. Not to my recollection. Judge. Well, I guess you're free to go, Mr. Crookeye. Have a nice night. In case you didn't know, if the officer writes up the ticket incorrectly, it has to be thrown out entirely. Also, I don't think the officer was trying to get me on extra charges on purpose. There was one of those signs at the top of a hill that warns of a bus stop over the crest of the hill. Think he just got confused. Story 25. Not a lawyer, but self-defended myself against an utterly nonsense charge of using my cell phone, which was turned off charging, while driving. When the cop pulled me over and said it was because he saw me using my cell phone at a light, I told him that was impossible. It was turned off, and I would happily turn it back on and show him it hadn't been used in over 10 months. He refused to see it and wrote the ticket, $590. I was pissed. I'll own up if I make a mistake. I once got a ticket for going 81 in a 60 zone that I thought was an 80. I didn't even fight because I was in the wrong, even if I wasn't knowingly speeding. But this was complete nonsense. I didn't really think I had a chance, but hoped the cop wouldn't show. My luck he did, and then the prosecutor showed me his statement. He lied and said I told him I had just been checking my messages. Well, when he pulled me over and I told him I'd show him my phone, I took screenshots of my call list, my email account, and my text messages, all of which showed the time of the screenshot and the last call, email retrieval, text sent or received. Judge let me admit them as evidence because his statement specifically indicated I admitted doing something relevant to the screenshots. And they, of course, proved that I had not used the phone for any of those things. Strike one against him. Then, when he testified, he said that he had seen me pull my phone out of the cup holder, look at it, and put it back in. My phone was on a dash mount when he pulled me over. So I asked him about the cup holder, and he said it was dash-mounted. I actually had a picture of the interior of my car, because I thought maybe he's seen me touching the screen of my car's controls. I drive a Prius. So I'd taken a picture of the interior. That, of course, showed the cup holders are not on the dash, and instead are in a console in between the driver and passenger seats. Strike two against him. Finally, I produced my cell phone records that showed I owned an iPhone 6 Plus at the time of the ticket. I asked him again if he was certain I'd put it in a cup holder, and he said he was. He could hardly change his story on the stand. So I took a cup that was on the desk, in case people needed water during the trial, and set it and my phone in front of him, and asked him to try to put my phone into the cup. 6 Plus phones were huge, and I use an OtterBox Defender. There was no way it would fit in a cup holder. He glared at me and said, "Well, the cup holders in my truck are big, it would fit in them." I reminded him the ticket showed I drive a Prius, and they are not a big car. Third strike. 3 times I proved that what he said could not have happened. The judge at this point interrupted. She said at the start she would provide advice since I was representing myself and that was part of her job, and said I'd made my point and did it very well. That was when I knew I'd won. And boy, was that cop pissed. But it was a glorious moment for me. Story 26. I am not a lawyer, but I've been up against plenty of them as a union chief steward. Years ago, we had an arbitration related to healthcare costs. The company spent the better part of a year trying to break us from pursuing the case. The day had come for our arbitration. The lawyer, there were 3 actually, we were up against was actually Paul Newman's nephew. Anyway, it was my turn to take the stand. His first question to me was presenting the grievance as evidence and asking me what step it said it was on at the top of the page. Our grievance process is a 2-step system, progressing to arbitration if it's not settled. I said, second step. Then he smugly asks, and where is the first step? To which I replied, the first step is a verbal discussion. It goes into writing at the second step. He looked hurt, but persevered anyway. A few more questions in, he asked, if the entire company got base-level insurance instead of a premium option that would satisfy the contract. At this point, he was hoping I would argue that the base-level insurance wasn't sufficient because he was trying to paint the picture that we were just trying to get premium insurance at a base-level price. I responded with yes. He looked dumbfounded, asked me, yes? I said again, yes, that would satisfy the language in the contract. He kind of looked at his other papers he was going to submit as evidence, then muttered no further questions. I knew at that moment that they had brought no real argument to the table. We got our answer from the arbitrator 6 weeks later, during a contract negotiations meeting. It was insanely satisfying watching them read the email during one of the sessions, and the immediate shift in demeanor from their side of the table. They got real quiet. We were awarded 100% of the arbitration, full back pay for all employees that were being overcharged, and reduced rate for the premium insurance. Story 27. I sort of have an opposite. He knew when he lost it one. When I was about 4 years old, I was ill one day, and the only option my parents had to take care of me was for my dad to take me to work with him. My dad was an attorney, and work was the courthouse where he was arguing a case that day. My dad knew the judge and I was allowed to lay down on a bench during arguments from the two attorneys present, Dad and opposing counsel. I was a pretty well-behaved kid, I guess, and was quiet and just sort of laid down on the bench and stayed silent. I have vague memories of the incident, but nothing really defined. As my dad tells the story, the judge grew bored at one point, looked over to me, waved and gave me a smile, and commented on how well-behaved I'd been during all of this. Dad said it was at that moment the opposing counsel knew he'd lost the argument and subsequently the case. Dad joked about needing to take me to court more often. Story 28. I'm arguing a motion for summary judgment in front of a judge who has never ruled my way on anything ever. I was expecting to go home with nothing. He's holding the hearing in chambers, so we're all sitting around a conference table. I make my arguments and say, and I have 6 recent cases all supporting this. He says, and you brought cases. That's asterisk amazing, asterisk. I thought he was being sarcastic, and he was, but not for the reason I thought. While I thought my motion was dead in the water, he was a step ahead of me. He didn't need to see my precedent. I finish my 10-minute presentation, and then it's opposing counsel's turn. She starts arguing, and when she's done, I say, may I have 1 minute for rebuttal? The judge says, you're not going to need that, asterisk. And just like that, it clicked. He was ruling in my favor. In fact, he'd known all along my motion was solid because he'd read it. He'd denied my last 2 motions on discovery matters because he knew where this case was going. He knew he was going to grant summary judgment, and there was no point. He granted my motion, and that was it. I won the case, no trial necessary. It's rare to get summary judgment in my area of practice, and I was stunned. Excited, but stunned. That was my last hearing with him before he retired. It made me rethink how I size up judges. My expectations were completely wrong, and I should have given him more credit walking into the hearing. Story 29. The plaintiff was being deposed in the lawsuit she filed alleging close relationship discrimination. She was claiming her boss had made some inappropriate innuendos and overtures. The defense attorney asked her if when the alleged statements or events took place, was she shocked? No. Was she offended? No. Was she damaged in any way? No. So why exactly are we here? Well, honestly, I'd rather not be. Meanwhile, her attorney stared straight down, scribbling notes, doodling. We ended the deposition there and asked her attorney if this was going away now. We got a call later offering to settle for $1,000 and a letter of apology. My best guess is she was pressured by a friend or family to talk to an attorney, and the lawyers ran with it without really talking to their client. Story 30. My attorney had this moment in my initial consultation with him for my BWI charge. Yes, boating. The sheriff's department conducted the field sobriety tests on the deck or their small vessel in a heavily traveled waterway rather than taking me to dry land. Charges were thrown immediately out after my attorney brought this to the attention of the DA. Edit. I should add, this attorney was a sheriff's deputy on Marine Patrol for 12 years prior to going to law school. I interviewed 3 different attorneys and he was the last. The other 2 quoted me $35K for the defense. He said that he would never tell a client a case is a slam dunk, but he charged $700 and said he would see the case through trial. It didn't get dismissed with no additional fee. It was thrown out by the end of the week. Story 31. It wasn't a trial, but during a deposition on a case where 2 former employees decided to start their own company in a very niche market, but decided to make their plans on company laptops they unsuccessfully tried to brick. One of the defendants was the one being deposed. She said she answered to a higher power than the company. When pressed on what that meant, she said herself. That got reused prominently at trial. Edit. Because multiple people have asked, and finding a clarification in the replies might be annoying, there isn't anything illegal about wanting to leave one company and start your own. The problem was how they did it, which was trying to poach existing clients while still employed, which breached their fiduciary duty, particularly of loyalty. I believe we also went after them for intentional interference with contract, as they weren't trying to solicit new clients for their business, but rather trying to get existing ones to break their contracts with our client. Using the company laptop to try to do it just made it way easier to catch them when the company IT guy found all the emails. And for privacy reasons, I won't say what industry it was, but to the person who asked, no, it was not a high-end escort service. I've never had to deal with one of those. I did have to ask a witness once about a sugar daddy website once, though. So that was fun. Story 32. I'm not a lawyer, but I took my old landlord to court when I was in college. They stole my security deposit over nonsense. They claimed I trashed the place, not knowing that I took pictures and video when I moved in and out. Their evidence was a VHS quality recording of going through a perfectly clean apartment in better condition than it was when I moved in. But then they opened up the top of the stove and found a single piece of elbow macaroni under it, holding it up triumphantly. That was the crux of their argument. The judge was not amused, and I got all my money back plus my lawyer fees and the filing fee. She then fought against her own lawyer to avoid paying him. Unpleasant person. Edit. Anytime you move into a place, take pictures, take video, make notes about any damage. When you move out, do the same thing along with noting any repairs you made. Pretty hard to argue against solid evidence. Protect yourself. Story 33. So I filed the lawsuit in January. We exchanged discovery. Each side sends questionnaires and gets carefully worded answers over the next few months. And I file a motion for summary judgment, meaning I'm asking the court to let me win the case without a jury because the case is so obvious. Right before I file this motion, I figure let's review the discovery materials and see if there's anything I missed. And what do you know, the other side made a massive mistake on literally just the 4th out of 100+ questions that I asked. It's a dog bite case, and every single time I asked about the bite, the response says something along the lines of, "We admit to this and that, but we deny that our dog was involved in any dog attack." Well, question 4 asks whether they admit that their dog was not leashed on the day when it bit my client, and they simply answer, admit, meaning they admit their dog was not leashed, and they admit that their dog was the one that bit my client. That was the one thing that was genuinely in dispute. They tried to argue at the hearing that it was a mistake, and they only meant to admit to the lack of a leash, but the judge held them to their word, most likely because the other evidence made it clear it could only have been their dog anyway. Edit. For everyone hating on this for being misleading and the reason everyone hates lawyers, I'll clarify that at the time I wrote the questions, I would not have dreamed that they would have the balls to deny their dog's involvement. Their dog obviously was the one that did it. They let their dog out every day, no leash, and it terrorized the neighborhood for months, terminating chickens, fighting with people's dogs, chasing cars, before it finally bit my client. It was the only dog that ever did this. And yet the insurance company tried to lowball my clients and refused to even cover their medical bills. So after 2 years of negotiating, they finally lawyered up. Story 34. Can't make $35K case with his witness. Gets smacked down for not knowing local rules. I did a quid pro quo case for a guy who was doing my firm's website. It was a breach of contract case for a credit card. The debt had been sold, and at the time of trial, the ad danum was something like $35K. The client brought me in late in the game. He's already gone to mandatory arbitration and lost. I get the case a week before the bench trial, and when going through the pleadings, etc., I realized that the plaintiff never sent a 237 notice. This is when one side tells the other that they need to make available either tangible evidence or a party witness at trial. Think subpoena, but less bite. So the plaintiff forgot to send this notice to the defendant that he needed to appear at the trial. Normally, if a defendant doesn't appear at a civil trial, you get the obvious. The judge only hears one side of the story and Def loses. When a 237 is given and the defendant doesn't show, the judge is supposed to infer that Def didn't show because his testimony would have hurt his case. Negative inference. But because this was a debt buyer, plaintiff had no actual knowledge that this credit card bill and charges belonged to my client. All they get is a single-page print out from the original debt holder saying they sold this debt, and if they're lucky, some copies of statements. They could easily have proven it by calling my guy as a witness. Even if client denies charges, plaintiff can make a good case because defendant's name is on the bill. It's to his address. The restaurant charges are for the sub shop on his block, etc. And all that would come out when the called Def as a witness. So I tell my guy wait down the street. We do pretrial motions and plaintiff asks for my client. I point out their procedural error and they panic. They put on their witness, who is some account rep at the debt buyer, and I object to hearsay on everything they try to get in. She has no knowledge, can't lay foundation for statements, and the only thing she can remotely testify to is her own business record. The single page showing a debt sale. Not enough. Then plaintiff attorney gets a bright idea. He starts to ask his witness about the arbitration hearing. I see where he's going and let it play out a bit. He's trying to get in an admission of party opponent. Basically, witness can say that at the arbitration hearing, my client admitted this was his debt, but this is an out-of-town attorney. He doesn't realize that because arbitration is mandatory and has very relaxed evidentiary rules, all evidence comes in if you tell the other side what you're going to use, that this county considers arbitrations to be the equivalent of settlement conferences and the testimony isn't admissible at trial except to impeach. Result, directed finding for my client, who saved himself a $35,000 judgment. Judge praises my defense, and I get to make super fake small talk in the tiny elevator with the plaintiff and his witness after trial, where I walk out to hand my client the court order in his favor. Most satisfying win, ever. Story 35. I knew the cops beat up my client and framed him. They described a knife in his possession that caused them to fear for their safety. Oddly, they never seized it. We won the criminal case and filed a civil rights case. While deposing one, he described the knife in detail. No more than 3 minutes later, he slipped up and claimed his partner told him my guy had a knife, but he never saw it himself. I told him, "That's not what you just said," and saw him panic. His lawyer panicked, too, and asked to see me outside. When we got in the hallway, I withdrew my settlement demand, and the case settled for a substantially larger amount within 45 minutes.